everybody. Welcome to True Crime Wednesday. If you are new, welcome. My name is Lori Hellis. I'm a retired criminal attorney writing true crime books and talking about true crime with you all. And we weren't here last week because on Wednesday morning, we woke up to quite a shock. Those of you who get the community notices on YouTube know that I live in Central Oregon and it's cold here. And we routinely have to safeguard our homes against frozen pipes. So I got up on Wednesday morning, and my darling neighbor across the street who walks his kid to the school bus stop every morning sent me a text and said, "Do you know you have water running down your sidewalk and into the storm drain?" So I went out and took a look, and sure enough, there was a lot of water bubbling up from out of the ground. And it wasn't our irrigation or sprinkler system. It was coming from much deeper. Well, we called the city. The city came out. They turned off the water. They told us that it was leaking at a rate of about 500 gallons an hour, which is a lot. And so then we went about trying to get it all fixed because it was on our property and not on the city side. But it was in a pipe, the main supply pipe that comes from the street, from the meter to our house. And so they had to turn our water off. So we were without water from Wednesday morning until Friday morning when we finally got it all fixed. So it was a lot to deal with. And we had to have a separate company come out and do the excavation because plumbers aren't excavators, and the pipe was about 3.5 feet down. So yeah, it was a big job, a big deal. So I'm glad to have that behind us. And but it's been very cold here. We have snow on the ground, and it's supposed to snow on and off and be below freezing here for the rest of the week and probably into next week. So I'm super envious because my kids are leaving for Hawaii on Saturday. And they've got a family trip with my son-in-law's family planned to go to Hawaii. So they're on their way to Kauai. And then the next week, my husband's headed for Phoenix for actually surprise for some college baseball spring tournaments. And I'm jelly of both of them. However, I am looking forward to being in Tucson for the Tucson Festival of Books in the end or mid-March. And I'll post those dates for everybody so you all have them. I'd love to see you if you're in the Tucson area. I'm also going to be going up to Phoenix for a book signing at a bookstore in downtown Phoenix. So I'll make sure that information is all out there. And please, 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 if you are in the area, stop by and say hello. So we have a lot to talk about tonight, and I'm kind of taking my time while we let people join. I do want to talk a little bit later when everybody's here, kind of about where the channel goes. So stick around because I want to have that conversation with you, and I really do want it to be a conversation. I want to hear from all of you what's happening and whether or not what I'm doing at this point is working for you or whether it's just kind of repetitive. So we'll talk about all those things, but I want to wait until we're a little further into the show and more people have caught up with us. So I do want to catch up on some things that we didn't get to talk about last week when I was dealing with broken pipes. And one of the things that I wanted to talk about was Karen Reed. Now, there have been several motions that have been filed recently. As you know, there's a run up to her trial, which is on April 1st, when her retrial starts. So there have been some things going on. Sorry, I'm a little froggy. I have seen an allergist and I am working on it. It's just not an easy fix, as it turns out. So there have been several motions that have been filed for Karen Read as we get in the run up toward trial. And the prosecution has filed several motions challenging experts. So let's talk a little bit about what that process is. So if you have an expert that you want to have them testify at trial, you have to be able to provide the other side with adequate information about that person's qualifications so that they can determine whether or not that person is an expert. Now, typically what happens is if one or the other, one side or the other, has concerns about whether an expert is actually qualified, they can ask the court to hold what's called a Daubert hearing. Oh, that was my other screen on the other side here was very bright, so I was just putting it to sleep so it wasn't blinding me. So either side has the right to ask the court to have a hearing pre-trial hearing to examine that expert and determine whether that expert is actually qualified to give the expert opinion that they've been asked to do. So what that means is typically that hearing has to do with, first of all, whether or not the information that that expert is going to bring forward is actually scientifically supported. Okay, so it's not just smoke and mirrors, or it's not just somebody's opinion. It's actually scientific, based in science. And then the next question is that person qualified to give an opinion based on that science? So the first thing is, the first motion had to do with challenging Dr. Stephanie Russell. If you remember in Karen's earlier case, Dr. Russell came to the attention of the defense kind of mid-trial. And she presented herself as an expert on dog bites. And to be honest, she is an expert on dog bites. She is someone who has worked extensively in the emergency room. She's worked extensively in, also she is a forensic pathologist, so she has that background, done autopsies, that sort of thing. So she's definitely familiar with wounds and how wounds are created and what they look like on the body. And in addition, she worked in law enforcement before she went to medical school. And she also has experience working with police organizations and their police dogs, and actually providing medical care when police dogs get a little bit too rambunctious or a little bit too excited in their training. So she has all of this extensive background in dog bite training. So the prosecution this time said, I don't know, we're going to challenge her as being a real expert. I can see that based on the fact that this area is a little esoteric. I mean, not everybody's a dog bite expert. And, I could see them looking at her and saying, well, what makes you a dog bite expert? But, when you look at her qualifications and you hear what she's done, you're like, yeah, I bet you have seen hundreds of dog bites and injuries from dogs' scratches and teeth. So they had that hearing. Dr. Russell came and testified. They had her on the stand. They had to break up her testimony, so she had to come back. And they did a lengthy Daubert hearing, is what they're called. Daubert is the federal Supreme Court case that stands for the proposition that experts can be challenged and have to be qualified. And so, and it's set, Daubert is what sets out the criteria for how you decide an expert's qualified. So they had the Daubert hearing. Judge Cannoni found that she was qualified, although said it was kind of a close call. So, but what has been going on is that pretty consistently, the prosecution has been challenging all of the defense witnesses. Now, what isn't appropriate for a Daubert hearing is when experts disagree. If they disagree on methodology, if they disagree on what data means, that is something a jury has to weigh. That is not a Daubert hearing. But as others have pointed out, the prosecution seems to be using these Daubert hearings as a kind of an end run on being able to depose experts, which in Massachusetts they can't do. So they don't have the opportunity to depose experts ahead of time. So they're kind of using this as a bit of an end run to get around that and find out what it is the experts are going to say. So the next challenge that they made was to Mr. Green, who is the defense's cell phone expert. Now, there's been a tremendous amount of controversy about when Jennifer McCabe made a Google search asking how long it takes to die in the snow. Initially, the timestamp said 2:36 in the morning or something like that. But the prosecution claimed, their expert claimed, that was somehow incorrect, that it was an artifact, that it registered that way because she had a search tab open and a whole bunch of sort of convoluted reasoning. So when the defense brought their guy in, who appears to be very qualified to do these assessments and very experienced, the state's expert was not as experienced and not as qualified, but they're trying to get him thrown out because he says, oh, no, that search was done at 2:30. Jen McCabe did that search on her phone, searched for how long to die in the snow at 2:30 in the morning. And the other side's reasoning makes no sense at all. And so now what the prosecution has done is they have challenged Richard Green, saying that his methodology has been debunked. So I think it's really insulting when and very prejudicial for the state to file a motion that says in its caption, in the motion is titled "Motion to exclude Richard Green's debunked theories and debunked testimony." I think that was very inappropriate. This Brennan, Hank Brennan, I think is his name, he's actually been brought on as a special prosecutor, and he's actually a defense attorney, so shame on him. I'm sure if he were on the defense side, he would have been calling them to task right away over that. However, so there was a hearing. The way that a Daubert hearing works is, first of all, the judge has to decide whether or not a full hearing on the issue is needed. And so they had a hearing to set a hearing. I know, trust me, I know. But they had a hearing to set a hearing. So at the hearing, the judge heard the arguments for why they thought they needed a hearing. And the defense lawyer just kind of cleaned up on Hank Brennan, frankly. And the outcome was the judge said, I don't need a hearing to decide this. I can decide it on the pleadings, on what's been submitted, on the motions. So I think we're going to get a ruling on that fairly soon. But the defense also made a new motion. So the state made the motion about the Daubert hearing. But the defense made a motion, and this one is pretty interesting because if this is true, it could be pretty bad for the prosecution. So what they contend is they filed this motion under the guise of we want to get reimbursed for money that we expended trying to get discovery that doesn't exist. So what happened was the defense sent their experts. The defense called the state and said, hey, we want to send our expert down there because our expert is an expert on surveillance cameras, and we want our expert to come down and get and extract from the Canton Police Department's system the raw data from that Sallyport video. Now, if you remember, the Sallyport video wasn't even turned over to, oh, hello, Kat. The Sallyport video wasn't even turned over to the defense until trial was already underway, and the prosecution decided they wanted to use it. When they presented it, it was transposed. It was reversed. So everything in the background was backwards, but what was weird was the timestamp on the bottom was forward. So only some of it was mirror imaged. But what it meant was that the state was contending that the video made it appear the car was reversed, and the state was contending that nobody went near the taillight that supposedly was broken, and so couldn't have taken the pieces and taken them back out and scattered them around the site, or however, and so that appeared it appeared to show that nobody was around that taillight. That didn't necessarily make sense if what they were looking for was damage to the car. But in fact, when you turn the picture right side out, they actually were. Everyone was kind of clustered around that taillight. So it didn't show what the state said it was going to show, and in fact worked in favor of the defense. But the defense said, wait a minute, we really need the raw data extracted right off of the server at the police department in order for our expert to be able to dig into all the metadata. Now, metadata, I am not an expert, so I'm going to tell you what I understand. The metadata, which is embedded in the video, is the information about the time it was taken, what turned on, what turned off, if there were breaks, and it's actually just all of the raw data and the background information about how that video was created. So they said, because of all this controversy about this video, we want to send our expert down there to extract that information off the law enforcement, off the Canton PD's server. And everybody said, yeah, sure, send him on down there. So the guy goes from Phoenix, where he lives, to Massachusetts, to Boston, and he gets to the police department and he says, I'm here to extract all that information off your server. And they say, well, we don't have it because that server overwrites every 30 days. And so it's not stored anywhere. The only thing we have is the copy we made. And that copy doesn't necessarily contain all of the metadata. Well, we know that they have a copy of it because they produced it, and we know that they had it fairly within 30 days after it was recorded. But they don't take pains to copy all the metadata. All they do is copy the file that has the images on it and put it onto their main server. And but no one told them that. Nobody knew that. All they knew was that there was a copy and they could go get it. So the expert gets down there and he's made a fruitless trip. And it also turns out that they didn't preserve that evidence. So now what we have is probably a Brady violation, a violation of Brady versus Maryland, which is the federal case that determined that that covers discovery, and that the prosecution has to turn over all discovery to the defense. Now, the issue is, and they have to turn over discovery that's exculpatory or could be used for impeachment. So in both cases, this is clearly could be exculpatory. I mean, if what they show, if what that video shows is a cracked taillight, and they came to trial and brought out all these little pieces of a taillight that they discovered at the scene, those two things don't jive. So what that means is that taillight was damaged afterwards, and the pieces were scattered at the scene. If when they pull that car into the Sally Port and they've taken possession of the car, the only thing that, as the defense alleges, the only damage is a crack to that taillight that happened when she backed into John O'Keefe's car in the driveway on the way out to look for him. So it could very well be a pretty serious Brady violation, serious enough that it could warrant a dismissal. So at best, it was negligent. So think about Alec Baldwin's case, and that his case got dismissed for discovery violations. Probably not quite as heinous as this one. Do I think Judge Cannoni is going to do that? No, I don't. But it is possible, and they absolutely have to raise it for appeal. So on appeal, they, in this motion to get $12,000 in compensation from the state for this wild goose chase they were sent on, they also say that they're going to file a motion to dismiss based on the Brady violations. So we need to wait and see what that's going to look like. But there's certainly going to be a motion to dismiss coming. So right now, Judge Cannoni has set aside, I want to say it's next Thursday and Friday, as motion days on the Reed case. So, but there's another. Now, we have talked a lot about some of the other cases, some of the other fishy cases that are going on around Boston. So we've talked about Sandra Birchmore. She was the young woman who was an Explorer Scout in the one of the local suburban police departments near Canton, one of the Boston suburbs. The suburb is called Stoughton. And she was an Explorer Scout there from the time she was like 13, always wanted to be a police officer. Explorer Scouts are sort of like Cub Scout or Boy Scouts, but they're more work specific. So kids who are interested in, say, aviation might have an explorer post that works with an aviation company or police department, fire departments, those sorts of things. So this was an Explorer Scout post that was hosted and sponsored by the Stoughton Police Department. And Sandra Birchmore was an Explorer Scout, wanted to be a police officer. Over the period of time that she was an Explorer Scout, she was groomed and ended up in a relationship with one of the officers, a married police officer. They had sort of a lengthy relationship that started far before she was an adult, started when she was somewhere between 13 and 15. She was 23. They had sort of continued this on and off relationship, and she had discovered that she was pregnant with this officer's child. And she turned up dead in her apartment, and it was staged to look like she had taken her own life. And initially, the medical examiner ruled it a suicide. I know YouTube's might have a fit about that, but I don't make any money off this anyway. So they initially they ruled it self-harm. Then later they changed their evaluation when more information came on, that it was clear that it had been staged to look like that. And one of the Stoughton, the father of the child, was arrested, and he still has not gone to trial. But because it was a police agency, they brought the Canton Police Department and the Massachusetts State Police, Michael Proctor, in to do the investigation. And we all know about Proctor. He's on administrative leave, unpaid administrative leave, and he recently met with the board and the discipline board, and he may be in pretty short order being fired. So he's a problem. He's a problem for the prosecution in any of these cases that are coming up out of Boston and out of the suburban Boston area. So that was Sandra Birchmore. Then we have Brian Walsh, who was accused of murdering his wife. Her body's never been found, but enough evidence was found to charge him. Her name was Anna Walsh, and he's in jail. And Michael Proctor was the lead investigator on that one. So there's a lot going on, but there's another case that came to my attention and is pretty interesting when you look at all of the stuff going on around Karen Read. So I do want to say shout out to Melanie Little, who does a great job of covering these cases. She's part of the LawTube group, and she's a lawyer from New York. And she's been all over the Karen Read case. She's been very interested and involved in that, and also really interested in some of the other kind of cases on the fringes of the Read case that sort of show the corruption and the problems with law enforcement there. So one that came to her attention, and she's been covering all week, is the case of Peggy McGee. She lived in another suburb in Brookline, apparently. And I had to admit, it was a really crazy case, and nobody was really covering it. Court TV wasn't covering it. Law and Crime wasn't covering it. The local news in Boston wasn't really covering it. Apparently, Court TV did a live feed for part of one day in the courtroom, but that was it. So Melanie has been following it and has been doing a live stream of the Zoom feed. So there was no video, just audio. But here's the really interesting thing. Judge Cannoni, who is the judge on the Karen Reed case, was the judge on this case. To make it even more interesting, this woman waived jury and asked for the judge to rule on guilt or innocence. So she had a bench trial. And when you hear a little bit more about this case, you go, wow, that makes perfect sense for her to have a bench trial. So here, let me just give you a quick little background on what happened. She and her former husband had been divorced for quite a long, 7 years or so, and quite a few years. And they were co-parenting children, 3 kids, I think. And the ex-husband's family was quite wealthy. He wasn't particularly quite wealthy, although he was politically connected. He had been involved in Democratic politics and had actually run Michael Dukakis's campaign at one point. So he did have some political connections, but he wasn't wealthy, although his 2 other brothers are very wealthy. So apparently there was a trust that with his brothers that owned a home, and Penny McGee was living in that home as a rental, and they decided to evict her out of this. Yeah, that's my cat up there on the cat tree, this tail hanging down. I don't know if you can see him or not. So anyway, they evicted her from this rental home. And she didn't really have anywhere to stay. So her ex-husband said, well, you can stay in one of my guest rooms temporarily. But she was estranged from their youngest child, the daughter, who was just finishing high school. And he said, I just don't want the 2 of you, I don't want her feeling pressured, or so you can't be here when she's here. And she agreed. So she'd been there a few days, I think, maybe a week, kind of coming and going. And she got an email from the brother who was managing the trust and the rental house. And she was upset about it. So somebody said she went over there to confront him. Well, she didn't, because she was actually living there, staying there. But she did go to him and say, what the heck is this about this email? Nobody really knows what the email said, other than the fact that it had some that brought up something that was a conflict for them. And they got into an argument. Now, there's conflicting information about this argument. Some people say that he was the aggressor. He was pushing and shoving her. She says that. The daughter says she saw her mom slap him. So at some point, there was a physical altercation. No physical altercation is okay, but this was a fairly minor one. Some pushing and shoving, hair pulling. And as they were in this argument, he suddenly collapsed in the foyer of the house with a heart attack. He was in very ill health. He had recently had a stroke. Just a few days before, had been in an accident where he totaled his car because he was having vision issues and cognition issues. The autopsy showed that that the two major arteries were 90% occluded going into his heart. So he was in very fragile health to begin with, and he had a heart attack. When it happened, she administered CPR until 911, until EMTs got there, and when of course the daughter had called the police because of the altercation. EMTs arrived, rushed him to the hospital, where he later was pronounced dead, having had a massive heart attack, the kind of heart attack they call a widowmaker. And but it wasn't until almost a year later that they charged her with manslaughter as a result. And it wasn't until almost a year later that the medical examiner changed the cause of death from natural causes to homicide. And that was based on the fact that they'd had an argument. And it really was kind of an outrageous prosecution. I definitely recommend that you take a look at the videos from the last week with Melanie Little, because she really did get involved in that. And that's because she's had a lot of interest in the Karen Read case. And a lot of these people are the same players. So Judge Cannoni is hearing this case, and she is the trier of fact. So typically what happens in a case is the jury makes that determination of guilt or innocence. They're the trier of fact. They're the ones who hear all the evidence and decide what they believe and what they don't believe and all of that. But defendants do have the ability to waive jury. I think that they took one look at the fact that they took one look at the Karen Read trial and said, this is a case where we really need somebody who will apply the law and understand the law. And we don't trust that a jury would be able to do that. So they tried the case to Judge Cannoni. And today, Judge Cannoni found her not guilty. And she walked. That was fascinating. It was very interesting to listen to. The defense attorney, I think his name is Tippett or Tipler. I'm not positive. He is also the defense attorney for Brian Walsh, and he's a public defender. He did an absolutely excellent job. So that is worth tuning into if you're interested, because it really does sort of give some insight into what we can expect when Karen Read goes on trial in April again. And it was interesting to see Judge Cannoni in a different case, because a lot of people have felt like she is pretty biased toward the state, and that she has been pretty hard on the defense. I don't necessarily disagree. I think that there have been times when she has not been particularly fair to the defense. So it was interesting to see her in a completely different case, in a completely different context, and definitely worth looking at if you're a trial geek. Because I thought that you don't often see bench trials. So there was one other not guilty finding today, and that was Colin Griffith. I don't know how many of you were following that case. He's a young guy. I don't even think he was an adult. I think he was being tried as an adult, but I think he was 17 at the time this happened. It's kind of a funny case, because the rules of evidence did not allow the jury to hear some of the things the public knows about this case. And one of the things is that he killed his father in what was found to be an act of self-defense in Oklahoma a year or two before. And he had been living with his father. Now, neither one of these parents are model parents in any way. And there was a lot of domestic violence, a lot of abuse. And so the police found that the killing of his father was self-defense, and they did not ask the prosecution to bring charges. So after that event, he goes to live with his mother. Now, his mother's situation is not a lot better. There's a lot of domestic violence, a lot of abuse, a lot of really unpleasant and unhappy conflict going on. And in an incident of domestic violence, he killed his mother. He claimed that once again, that it was self-defense. And at least one of the police said he thought that it was suicide by son, meaning that the mother was responsible. And today, a jury, now not a judge, but a jury, found him not guilty. I think everyone was pretty surprised at the outcome on that one. I wasn't following it. I did, when it popped up on YouTube, I watched the verdict and then kind of went back and watched a little bit about it, but I didn't follow the entire trial, so I'm not that familiar with the facts or what came up at trial. So, and then, there's a couple of little updates on Lori Vallow. She filed a motion to dismiss her case because her speedy trial rights were violated. If you recall, when initially she got to Arizona, she said, I want a speedy trial, and they set trial dates. Then her court-appointed lawyers came back and said that they wanted the case designated as a complex case because that gave them more time. And it certainly is a complex case with the volume of discovery. So they wanted it designated as a complex case. The judge agreed and then set the trial date out. So instead of 180 days, they had 270 days. In the meantime, those attorneys withdrew at Lori's request, and she got new lawyers. Those lawyers came on board and said, we have so much discovery. We've got 100,000 pages of discovery, and we've been through 8,000. So there's just no way that we can be ready for a trial. So the judge once again set the trial out. Now, I think there's an argument to be made that she's the one who wanted different lawyers, and she couldn't expect to keep that trial date if she got new lawyers. So then she asked to represent herself. So the same lawyers are continuing on with her as advisory counsel. So she filed a motion saying that, and then there was another delay. It wasn't very long, maybe a couple of weeks, when the attorneys that are now her advisory counsel filed a motion asking for her to be evaluated for competency. At that point, when they asked to have her competency reviewed, she said, I don't want these guys anymore. I'm going to represent myself. So once the evaluation came back that, yes, in fact, she was competent, the judge had a conversation with her from the bench, and she said no, that she wanted to represent herself. And he said, okay, you can. Now she's been filing all of her own motions. They're all handwritten. And and her attorneys have been just there as advisors if she needs them. So the trial date is set for the 31st of March. She filed this motion saying that she didn't get a speedy trial and wants the case dismissed. And the judge, there was a brief hearing on it. She made her argument, and just recently the judge denied that motion. So the trying to remember. Oh, the prosecution asked the court to set parameters for, and I think it was triggered by the fact that Court TV filed a motion to be allowed to live stream the trial. And the prosecution came back and said, we're okay with the live stream, but we want some parameters. We want there to be enough of a delay that if there's something that's revealed that shouldn't be, that it can be redacted. We want to be assured that sidebars and attorney-client conferences or lawyer conferences aren't picked up on the microphones. And so they said, we don't mind it, but we want parameters. Lori Vallow came back and said she objected to having the cameras there. She didn't want any cameras, which I think is really interesting because she's always enjoyed being in front of the cameras. But I think that she felt like she didn't, that she doesn't like Court TV because I think she felt like they weren't fair to her and made her look bad. So she's opposing the cameras. No ruling's been made on that, but if I had to guess, I think the judge may put some governing on the way that it's done, but I think that he'll allow it. He's allowed it all along. So all of the pretrial hearings have been televised. So I think that's probably what'll happen. So I want to go back and talk about Delphi because something's come up that that I wanted to clarify, because there's a couple of people who not lawyers, not the LawTube folks understand this, but there were a couple of folks out there that were talking about this that maybe didn't quite understand the nuance of this. So Richard Allen's lawyers filed a motion, and states vary on how people do this. Sometimes it's for a new trial. In this case, they filed a motion to correct error, and essentially asking for a new trial based on the fact that there were errors in the first trial. So I want to go back and just kind of refresh everybody about some of the things that happened pre-trial. So pre-trial, there were 3 police officers who were assigned as part of the investigation into the deaths of Abby and Libby. And they felt like the crime scene was very unusual, and they pursued the possibility that there was some sort of a ritual of some kind. And they presented their evidence and brought in an expert from the behavioral unit of the FBI. And the FBI confirmed for them that they felt like the crime scene was related in some way to Odinism. Odinism is a Norse religion. It's a pagan Norse religion. Now, what the FBI experts said, or what we've heard they said, we haven't seen any of these documents, but what we hear is that the FBI said, yes, these sticks that were laid on the bodies, these symbols that were drawn in blood, these are Norse religious symbols. And these are runes that are used by people who practice Odinism. So they sent all that information to the Central Command, and it disappeared. And it wasn't until one of the officers, now, and I mean, there's some other weird stuff. One of the 3 officers was gunned down in the street and died. One of the officers retired. And so when several years later, 5 years later, when Richard Allen was arrested, and this police officer saw on the probable cause affidavit, once it got unsealed online, he read the probable cause affidavit and said, wait a minute, there's nothing in here about this being related to Odinism or being any kind of a ritual killing. And that doesn't make any sense. How is Richard Allen connected to Odinism? So he went to a lawyer and consulted with a lawyer who helped him write a letter, which he sent certified mail to Nick McClelland, who is the prosecutor, with his notes and report. He attached the FBI report. He outlined what their findings were and said, this was all provided, but apparently it never went any farther. And so, and still, the prosecution did not provide any of that information to the defense. So that was a big Brady violation. And it wasn't until now in Indiana, you're allowed to depose witnesses. It varies from state to state. So my home state, no witness depositions. But in Indiana, you're allowed to do that. So as the defense is going forward and they're deposing all these witnesses, they get to the point where they're going to call this officer into a deposition, and the state knows it. And so they are up against it because they know this cop is going to talk about their investigation. So they finally turn this stuff over to the defense. Well, the defense already knew it was out there, and they were kind of waiting to get the prosecution to show that the prosecution had been withholding it. So they depose the cop. All this information comes out about the possibility of it being a Norse crime. So there's that. There's also a guy, the man whose property the bodies were found on. His name was Ron Logan. He died in 2021, I think, of COVID. So he's no longer around to depose and question. But he also had a lengthy criminal history and was in and out of prison, which means that because Odinism is rife in the prisons, and it is a religious belief system that is often associated with white supremacy, not blanket. I'm not saying that, not everybody, but it is, there are some parts of Odinism and some groups that practice Odinism that are also white supremacists. And it is very common in the prison system, in the white supremacist gangs and groups in prison. So the reason I say that is because Ron Logan, the property owner where the children's bodies were found, was in and out of prison and would have been exposed to that sort of belief system, that information, the runes, the symbols, those sorts of things. In a lot of prisons, it is recognized as a religious practice, and inmates are allowed to have religious ceremonies and the same way that they're allowed to have church on Sundays. So So Ron Logan would have, having been in and out of the local, the state prisons, been exposed to that as well. So two different theories for a third party who could be involved. So when the defense filed their motions asking to be allowed to present third-party culprit information, the idea that somebody other than Richard Allen was involved in the murder, the judge denied the motion. Now, here's what she said. She said that the standard is that there has to be some connection. Nexus is the legal term for it. There has to be some sort of logical connection between the crime and the perpetrator and this other third party. So it really, if you think about it, sort of arises to the same level as a probable cause evaluation. It's more likely than not. It doesn't have to be proof beyond a reasonable doubt. It only has to be 51% more likely than not that this person could have been involved. So there has to be that connection. Well, Judge Gull ruled that there was not a sufficient nexus between the crime and the perpetrator. So they were not allowed to bring that information in, either that some unknown odonist did this, or that Ron Logan made the scene look like odonists did it. Either way, they were not allowed to bring that information in before the jury. So what happened at trial, well, let me go back. So Ron Logan, while he was in prison, confessed to a cellmate that he was responsible for the murder of the girls. And he gave the guy a lot of detail about the crime and about the scene and about when he was there and about how it was committed. And one of the things that he said in that confession was, I used a box cutter. Now, when the coroner, when the medical examiner did the autopsies, the medical examiner said what was used to slit the girls' throats was two different knives, one blade and one that may have been serrated. And that was the finding that the medical examiner made up until trial. When the trial occurred, the medical examiner got on the stand and said, I realized not very long ago, matter of days or weeks, as I was thinking about this case and I was at my workbench and I picked up a box cutter and I realized that in fact was what made those imprints on the girls. It was not a serrated knife. It was the handle or the head of the box cutter. And he testified to that in trial. That was totally new information that had not been provided to the defense, that came out of the blue. Now, what we don't know is whether he had given that information to the prosecution and they had just not shared it, or whether, in fact, it was news to them too. We don't know that. But when the medical examiner got up there and testified for the first time in any report, any kind of information, any kind of preliminary hearings, that the murder weapon was a box cutter, suddenly there was a nexus between Ron Logan's confession to his cellmate that he used a box cutter and the crime. So a lot of people jumped to the conclusion that somehow this was a Brady violation, that this was discovery that was never provided to the defense, and that they didn't know about Ron Logan's confession. That's not true. They did know about Ron Logan's confession. So the confession itself isn't the new information. The new information is the information that came out at trial from the medical examiner. The new information is the medical examiner's testimony about the box cutter, because that creates the nexus, the connection between the crime scene and Ron Logan. And so now they're asking for a new trial based on the fact that that was newly discovered evidence. So no, there's no evidence. There wasn't newly discovered evidence that was withheld from them. But the connection between the two, the newly discovered evidence, was the fact that the coroner now, or the medical examiner now, says a box cutter was used. That's the new information. And that creates the nexus to Ron Logan's confession. So do I think that Judge Gull is going to agree and give them a new trial? Oh, hell no. She's never going to give them an inch. However, it does raise some more good issues for appeal. And one of the things that is, I think, going to be important, it lends more ammunition and more credence to the third-party culprit argument. So the new information is yes, and they want to get that on the record, because they want to say, hey, wait a minute, we would have prepared differently had we known that that the medical examiner was going to say box cutter was used, because we would have gone back to the court and said, we want to bring in the possibility of this third-party culprit, because there now is a nexus. So I hope that's clear. There are still motions flying fast and furious back and forth. Of course, the prosecution has now filed a response to their request, and I don't think it goes anywhere before Judge Gull, but and I think the other issue, I'm not really sure that the defense wants a new trial ordered right now, because right now it would be back in front of Judge Gull, and I don't think they would fare any better in front of Judge Gull this time than they did last time. So I just think I think they're better to go down the road of appeal, and I don't think I think they're making these motions for their appellate record, and not because they really want a new trial in front of Judge Gull. So hopefully that is as clear as mud. And I just have a couple of other things to mention before we get on to questions. The YNW Melly case, that's the one out of Florida with the rapper who, and we've had several of those. We had Young Thug, now we have somebody else that's being tried for a shooting. I can't, oh, come on. My brain just circuited. That's what happens when you get old and it gets late. So we've had quite a few of these. A lot of them they're pursuing under RICO. So they're pursuing them as even though there's a murder involved, they're pursuing them under RICO as a criminal operation. And so the thing about Melly is his first trial ended in a mistrial, and there's a lot of prosecutorial shenanigans going on. You think that Young Thug was bad with some of the prosecutorial misconduct there. This one's just as bad. The prosecutors are horrible. One of the things that happened was they began investigating ASAP Rocky. Thank you. Thank you. One of the things that happened in this trial was they began investigating potential witness tampering on the part of Melly, Demons is his last name, but his rap name is Melly. Anyway, they started investigating him for potential witness tampering, and in the process of that, said that they were also investigating one of his defense lawyers for potentially for witness tampering. Now, they issued a search warrant, but they have never brought charges. She's never been indicted, but it's like this black cloud hanging over her. So the defense came back and said, we want to see the search warrant. We want to see the probable cause affidavit. And we want to know what it is that the state is accusing this woman of. Because Melly needs to know that, to know whether or not at this point there is a conflict and that this lawyer has to get off his case. Because if she is also a co-defendant being accused along with Melly of tampering with witnesses, then their interests are now at odds and she can't represent him anymore. But the defense didn't really have any way to know because she's never been charged. It's just this thing hanging over. So the judge said that according to case law, the state did not have to turn over the probable cause affidavit, but they did have to turn over the search warrant. So he ordered that the search warrant be turned over and that Melly make a decision before the 18th of February on what he wanted to do about his lawyer, whether he wanted new counsel, whether he wanted all new counsel, whether he just wanted her off, whether he didn't want new counsel. So he needs to decide that. There has just been a ton of prosecutorial misconduct in that case. A lot of people have asked about the James Craig trial. That's the dentist in Colorado who poisoned his wife. He is due for a preliminary hearing on the 14th of February. I don't know whether that's going to be live streamed or not, but if it is, we'll cover it. And then lastly, about a month ago, some folks asked me about Shanna Gardner. Now, Shanna Gardner is a murder for hire case. She and her current husband are alleged to have hired a hitman to murder her former husband, Jared Bridegan. And what came up recently was only sort of peripherally involved in this case. And it was that the grandparents, her parents and his parents, were fighting over custody of her children because, of course, their father is dead and their mother is in jail awaiting trial on murder. And so what happened, just sort of factually, is when she left the state of Florida and went to Washington, where her parents are, with the children. And when she was arrested for the murder, she was arrested in Washington. And she left the children with her parents in the state of Washington. Jared Bridegan's parents have been attempting to have contact or get custody of the children. Now, they've been with the maternal grandparents, with Shanna Gardner's parents for some time while she's been waiting for trial. And so some people ask me about what happens in this kind of a case where mom is unavailable because she's in jail waiting trial on murder charges. Dad's unavailable because mom murdered him. And now the grandparents are fighting over who's actually going to have custody of the children. And just because Shanna Gardner is accused of having murdered the children's father, does that mean her parents are bad people or that they shouldn't have custody of the children? And so I wanted to talk a little bit about the civil law, the family law that kind of covers this sort of circumstance. So back in 2000, the US Supreme Court made a ruling based on a case out of Washington State about third-party custody, and it is called Troxel versus Granville. And it was a case where a stepfather was attempting to get custody of children after the children's mother had died, and over the objection of the children's biological father. And the state of Washington had a statute that said anybody can file for custody of a child. It was a very broad statute, and it was put in place, I think, to try and give grandparents some opportunities to get custody of their grandchildren. But it was the court ruled that it was overly broad and ruled that parents have a fundamental right to decide how they raise their children. So that's not new law. This goes back to parents deciding what school their child will go to, or whether that child gets medical attention, or whether they don't get medical attention because of religious beliefs, and many, many other decisions that over the years the Supreme Court has said parents have a fundamental right to make those kinds of decisions for their children. So the Supreme Court said parents are always going to be the one with the most the most compelling rights. Parents are their rights are always going to trump a third party's, unless the parents are unfit or unavailable, that there is a bond between the potential third party custodians, and if it is in the children's best interest. And in deciding whether it was in the children's best interest, the court had to weigh a bunch of factors. So the first threshold step was, are the parents available and able to make those decisions? So are they fit and able, available parents? If they are, then the discussion ends there. If they're found to be unfit or unavailable, then the next step is, what's in the best interest of the children? And the judge has to weigh a bunch of factors. And one of those factors is the level of attachment the children have with their current caregiver, that third party. Additionally, they have to think about the impact of on the children of restricting custody or visitation, or changing custody or restricting visitation. And they also have to ask whether or not in either situation there's been a history of abuse or neglect. And there's no indication with either of the grandparents that either of the grandparents had a history of abuse and neglect, either with these children or any other children. But the judge had to weigh what was in the best interest of these children. Now, they had been living with their maternal grandparents in Washington for quite some time, going to school up there, getting counseling up there, making connections up there, having friends and family around. And the judge in that case ruled that, yes, in fact, both parents were unavailable or unable to provide care for their children and make those critical decisions. But that when the judge weighed the two sets of grandparents, he came down on the side of the maternal grandparents, of Shanna Gardner's parents in Washington, mostly because they had a long time kind of established relationship with the children. One of the reasons why Jared Bridegan's family wanted custody was because the grandparents have not been particularly helpful in fostering a relationship between Jared Bridegan's second family, he and Shanna Gardner were divorced. They had 2 kids. Jared remarried. His wife's name is Kristen, I believe. And they had twins together. So they have younger children. And Shanna Gardner's parents had not been particularly helpful in facilitating either um, Jared's family or his children from having a relationship with their siblings. And they'd always had kind of shared custody before Jared was murdered. And the children had a relationship with one another. But the judge found that that wasn't a compelling enough reason to uproot the children from what was an established routine and an established connection for them, to allow them to change custody and have them move to the other grandparents. So I hope that explanation is helpful for anybody who was curious about what happens when people who have young children are no longer able to take care of them. You might recall in the Ruby Franke case, when the children were removed from her, and the 2 children were found. Now, some of Ruby Franke's children were adults. At least the elder 2, I think, were adults. We know that the oldest daughter has recently written a book, which I haven't read, but I understand is really interesting, about the background of that family. But initially, those kids were placed in foster care, and Kevin Franke, Ruby's husband, has been working to get custody of them. I don't know whether that's happened or not. And one of the things that's important to remember is that juvenile court actions, whether it's in this case, in the Gardner case, the custody issue was going to be decided in a civil case between both parties suing for custody, in family court. But in the case of Ruby Franke's children, because they went into foster care, they became wards of the state, and the juvenile system is where their custody was being decided. So in most states, juvenile court proceedings are confidential and to protect children. And so important to remember, they're kind of using two different pathways. And that means that Kevin Franke has to prove to the state of Utah that he's fit to have custody of the children. They have to make that determination. And we may not know when that determination gets made, because juvenile court is done confidentially. So we don't know whether those kids have been returned to him or not. But I think that if they haven't been, they will be. And we still don't know how long Ruby Franke and Jody Hildebrand will be in custody, because that is a decision that is made by the parole board in Utah. It's kind of a weird system. But we do know that there's been a very large civil suit filed against Jody Hildebrand by a husband who was encouraged or thrown out of his house in similar fashion to Kevin Franke, and who Jody Hildebrand brainwashed his family. And so he's filed a $5 million civil suit against Jody Hildebrand. Now, we know Jody Hildebrand had money. The house that the children were found in Ivins, Utah, was worth about $5 million. And it is on Zillow listed and is listed. But like a lot of houses that have kind of an unsavory history, I don't know how quickly it's going to sell. Apparently it's a massive house, and it's like an armed compound. It has a safe room and behind a metal safe door. And yeah, it's kind of eerie, creepy place. So I'm not sure it's going to sell really quickly, but I know that she's worth that at least. So with that, I think we're ready to take questions. While Jen is looking for questions, I want to chat with everybody about where we go from here. I've been thinking a lot recently about the channel and about how things have changed. So when I started doing the channel, there weren't that many law tubers. There weren't that many lawyers who were putting out as much content as they are now. So I started to think about, well, what am I going to do? Right now, I come on Wednesdays and we talk about cases, but they're cases that you've been following all week. You've seen the live streams. You've heard what Peter Traeger has to say about him, or Melanie Little, or Emily D. Baker. You've heard about what everybody else has to say about them. And to be honest, I don't want to waste your time. I don't want to waste people's time having you be here listening to me on a live when it's already stuff you already know. And so I started to think about, well, what do I do? Because a lot of these channels have expanded to daily coverage. I mean, every day you get Emily and you get Bob and Allie on Defense Diaries, and you get Peter Traeger on Lawyer You Know, and you get Melanie Little, and you get Andrea Burkhardt, and they do a fabulous job. But they are much more interested in creating a YouTube following and a YouTube channel. And that's really never been my jam. I've enjoyed this because I love connecting with all of you in this community. But, our numbers kind of dwindle a little bit every week. We're not getting a lot of new subscribers. And I completely understand that. I understand that it's because you can get this information on Monday that you don't get from me till Wednesday. And I completely understand that. So I'm looking for some thoughts from you all, because my heart's really not in expanding this into a daily show. My heart's really not in making this a massive true crime streaming trials and those sorts of things. My heart's really in writing my next book. And I have a project I'm pretty excited about and ready to dive into if everything comes together the way I hope it will. But I don't want to shortchange anybody. And I don't really know where we go from here, I guess. So I'm really hoping that you all will put stuff in the chat or post comments and let me know what your thoughts are. I love connecting with all of you. I love having that kind of interaction with all of you. And people seem to like the way I explain things. But on the other hand, I want to meet expectations. And I feel like, I don't know, I feel like sometimes I sit down and I prepare for Wednesday night and I go over all the cases and I think, well, what can I say about this that I didn't just hear on somebody else's channel? What can I say about this that isn't just something that you could have already heard on Monday? Because I don't think that's fair. I don't think it's fair to ask you to give up your Wednesday evenings to be with me if I'm not giving you any value for it, I'm just repeating stuff you already know. I'm not going to cry, I promise. But I love I love connecting with all of you. And it's been a huge part of my journey to write the Vallow Daybell book. And it's been a huge part of all of that. I just want to give you the best part of me that I can offer, knowing that my heart's really not in creating production value. You know, my heart's not really in getting a new studio and creating content every day and live streaming trials, and that's just not where it is. And I've always been honest with you guys, and I think you've always been honest with me. So I'm asking, let me know what it is that you would like to see me do. I'm I'm not necessarily going anywhere, but I'm asking the questions. Do we need to change things up? Do we need to change the date? Do we need to focus on a particular case at a time? Do we need to, do y'all want me to start talking about more in-depth legal issues? I mean, do you want me to start talking about what reasonable doubt is and what a Daubert hearing is, or do you want me to dive deep into that kind of stuff, or is what we're doing working for you? So just let me know. I really want to hear where your hearts are, and give me a little guidance on where we go from here. I'm not particularly monetized on YouTube. I get a few dollars off of YouTube advertising sometimes, but it's minor. And I never really did that. I never really did it for that purpose. But StreamYard just doubled their subscription fee a year, from $400 to almost $900. And, so it makes me sort of sit back and think, well, is what I'm doing valuable enough for you all to hang in there with me and for me to keep doing it? So you let me know. How about some questions, Jen? Oh, hi, Sharon. I think what you're talking about is the Richard Green expert in the Sharon Reed case. Absolutely nothing has changed. And that was the point that the defense made in really taking Hank Brennan to task, was saying this guy is eminently qualified, and you're trying to use a Daubert trial to fish for information. And that's not an appropriate use of a Daubert trial. And a Daubert trial is not where you challenge the findings of the other guy's expert. That's done at trial. The battle of the experts is whose opinion that the jury believes. But what they're trying to do is they're trying to get him thrown out so that the jury doesn't ever hear his opinion. I think it's BS, and nothing changed. I think he was eminently qualified before, and he is now. And in fact, what they brought out at the Daubert hearing was that he's in fact gone through and done even more investigation, based on what he heard from the prosecution during the trial. So I don't think this motion goes anywhere, and I don't think Judge Cannoni is going to entertain too many more Daubert motions before the 1st of April. Good question, though. Hi, Beth. My thoughts on the latest Adelson madness. So, yeah. So what happened was, Donna Adelson heard through the jail grapevine, that Katie Magbanowa, now we have to sort of go back a little bit and sort of remember who all the players are, because this is a really complicated case. So Charlie Adelson, who is Donna Adelson's son, the dentist, his girlfriend was Katie Magbanowa. She was a Latina woman. And he went to her and said, "Do you know anybody who can hurt somebody?" And she said, "Well, I might." And then she went to her baby daddy and his friend and solicited them to do the job of murdering Danny Markel. So Katie McGee was convicted for her role in the murder, along with Charlie and the two gunmen. So now we're on to Grandma Donna and the conspiracy. So now what's happened is that Donna Adelson got wind of the fact that somebody in the jail told her that Katie Magbanua had said that she set the Adelsons up and that she was going to be called to testify at Donna's trial. And if everything worked out, she was going to be on a beach somewhere drinking frosty drinks, something along that line. So the defense then filed a motion to be able to depose those two prisoners, both of whom it's likely are going to be released soon and might disappear and not be able to be found. And so they went before the judge and asked that they wanted to do really what amounts to a perpetuation deposition. So in most states, if you believe that a witness will be unavailable for some reason, and you want to perpetuate their testimony, you want to capture their testimony before they're not available. Say they're very ill and might die, or they're on death row and they're going to get executed, or a lot of other things as well, that you may want to capture their testimony while they're still able to give it. So that's essentially what they were trying to do. The judge denied the motion and said, "No, I'm sorry, but you're going to have to follow the rules and you're just going to have to subpoena them. And if you can't find them, that's on you." And but apparently at the hearing, Donna had a few things to say about what she'd heard. And so it was just more Donna drama. What I don't know is whether or not they finally set a trial date, because she had to get new lawyers. And I think they still have not set a new trial date. And then, of course, we have Charlie Adelson, who is trying to get a new trial because of the conflict between his lawyer and the fact that his lawyer represented both he and his mother. I don't know if he gets a new trial for that, because I think at different times they both waive that conflict. But the question is it waivable? And if it is, did they? So the appellate court's going to have to decide that. But yes, more Donner drama. It's definitely the case that keeps on giving. Hi, Jane. What do you think Jennifer Crumbley's chances are? I hope, because I feel like this is my defense attorney hat, okay? Guys, I'm a defense attorney. I really think that this was an unfair prosecution, to hold these parents responsible for the actions of their child. And I think one of the things that may very well get Jennifer Crumbley a new trial is the fact that the state did not disclose that they made a deal with the counselor and the teachers at the school, because truly the responsibility was on the school. The school knew that Ethan had issues and had problems, and the school knew that he was not doing well. The school was very aware, and the school didn't search his backpack, didn't insist that Jennifer take him home. In fact, they assured her that they had it handled and she didn't need to take him home. I mean, there was a multitude of junctures at which the school could have done a better job, and they didn't. And the fact that the prosecutors essentially gave them immunity in return for their testimony against Jennifer, I think that may get her a new trial. That was undisclosed, and that is a terrible Brady violation. Because I'm certain that her attorney would have approached that much differently had she known that the school officials all had deals. I mean, I sure would have. So I think that it's a possibility. I think that the appeal, based on the fact that extending manslaughter charges to the parents of a child that does a school shooting, I think it's really what we in the law call a case of first impression, meaning that it has not been decided before. The Supreme Court, the state Supreme Court hasn't decided this issue before about whether that statute can be applied to the parents. So I think there's some really ripe areas for a challenge, and I hope she does get a new trial. In fact, I hope that she gets a new trial and the state decides not to retry her. But we'll see. Hi, Rachel Gamber. Part 1. This makes me think of another question without giving specific details. There's a sad story not far from me where a mother and daughter were killed. Another daughter, age 6, survived. Okay, that's part 1. Let's have part 2. The parents were separated and the dad wants custody of his daughter, but because she's Native American descent via mom, she's being sent to live there. Oh, well, this is an interesting quirk, because on top of state child custody laws, there is something called the Indian Child Welfare Act, which is a federal law. And there's often a conflict between federal and state law when a Native American child is involved. So the Indian Child Welfare Act, the first thing you have to understand is that Native American tribes are sovereign governments within our country. It's a very interesting quirk, but it's the same thing, if you try and wrap your brain around it, that in Italy, in Rome, the Vatican is actually its own country. And that's exactly what has happened with Native American tribes. So for recognized Native American tribes, those that are recognized by the government, by the US government, they're considered sovereign nations within our country. And they have the right to create their own statutes and laws and court system and accountability, all those sorts of things. Now, not all tribes do that. Many of the smaller tribes have said, we don't want to have our own tribal courts. We don't want to have our own tribal statutes. We don't want to have our own tribal family law. We're going to agree that we fall under the state we're in, their statutes. But some of the larger tribes do have their own statutes and their own court system and their own tribal governments, and they do prosecute criminals and decide family cases and all those things within the tribe, usually on a reservation. But the Indian Child Welfare Act really came into the forefront because the US government had a long history of removing children from their native families and putting them in white boarding schools and inculcating them into white traditions, and they were trying to absorb them into white culture. And there are so many horrible stories about the Native American boarding schools. It's awful. And believe it or not, there are still some that exist in the US. They're fewer and fewer every year, but there are some. So the Indian Child Welfare Act was passed to give priority to placement of children who needed to be placed because of child welfare issues with Native American families. So this troubles me, though, because the Indian Child Welfare Act does not apply when the custody is between parents. Now, if dad had something to do with the death of the mother and the child, maybe that's the reason, because the child is actually in the child welfare system, like the Frankie kids. So if the child is in the child welfare system, then the Indian Child Welfare Act would apply, and the state is required to place the child with Native foster parents or with Native family. They're required to give priority to placing the child with Native American foster parents or family first, and then foster parents. So it would surprise me if the dad was unable to get custody, because he would be the preferred resource for that child, because he's the other parent. Well, in family law, if you have two parents, they both have equal parenting rights. They both have equal rights to be parents to a child. And the judge has to decide what's in the best interest of the child if the parents can't agree. But between the two parents, they have equal rights. The Indian Child Welfare Act wouldn't give mom, because she's Native, more rights than dad. So this sounds to me like a situation where, when the murder happened, the child ended up in the child welfare system, so a ward of the court, a ward of the state. And if that's the case, then the Indian Child Welfare Act requires that the state give preference to placement with family or Native fosters. So I don't know. She's never met this side of the family, and the bio dad wants her. Any thoughts on why this is? Well, it shouldn't be that way. It should not be that the Native American family gets priority over the biological father, as long as the biological father is able and available and willing. So it sounds to me like there's some other little quirk. So Rachel, here's what I would suggest. Since this happened near you, if you've got any news articles about this, drop them in my email to me so I can read them, because I could give you a fuller answer if I had all the facts. Because the Indian Child Welfare Act only applies to state actors. So the state acting as in loco parentis, in the place of the parent, because the child is a ward of the state. In that case, the state is required to give priority to the Native side of the family. But if this is just a disagreement between the two families, dad should prevail because he had just as much right as mom to be the custodial parent. So, but email me if you've got some news articles that I can look at, because I'd be really interested in that and happy to take a deeper look at it with more facts. Thanks for that, though. Hi, Beth. I think this is exactly the argument. How can you hold the parents in the school shooting case, in the Crumbly case? How can you hold the parents responsible for their minor child, but then try him as an adult and sentence him as an adult? Yeah, it does seem like having your cake and eating it too. I think there's a real, I don't know if it's a legal conflict, but it certainly is an intellectual, logical conflict. I mean, it certainly is illogical to think, okay, you were responsible for keeping your child from going in and shooting up a high school, but we're going to say he was an adult for the purpose of prosecuting him. Yeah. I agree. And I know that is an argument that they've made. I know that at the appellate level, that's, at the level of wanting to get her a new trial, I know that's an argument that they've made. I'm not sure it goes really far with the trial court judge, but the issue of undisclosed immunity agreements, that's huge. So I hope she does get a new trial. And I hope that the prosecution will get wise and decide not to retry her. I think they will, because I think they just have too much invested in it. But we'll see. So great questions tonight, guys. Anybody got anything else they want to chat about? We have 100 people in the chat, so please hit the subscribe and the like button if you like and enjoy what we're doing here. And I always want to say thanks to Jennifer, who is our wonderful moderator, irreplaceable moderator. So last call for questions, and otherwise I will look forward to reading the chat and looking at your comments to see where we go from here. I'm kind of open to some new ideas, and I don't, hi, Jane. I'm not quite ready to tell yet. I promise you that y'all will be the first to know, though. I've got a couple weeks, maybe 3 weeks or so before I'm going to have gelled it together to the point where I'm going to be willing to talk a lot about it. I'm working on a book proposal right now. The way it works when you write nonfiction is you write a very detailed book proposal with a book outline and some sample chapters, and that goes to my agent, and then my agent will start presenting it to publishers. So it's a case you guys are all familiar with, but I think I'm going to be able to have a little bit of a different take on it, and that's the part I'm really excited about. So I will absolutely tell you once I feel comfortable doing that. But I need to do a little bit more legwork and make sure that everything's going to come together the way I want it to before I start telling everybody. So I also have thought at length about a book about grandmothers who get involved in murder to get their grandkids. So there are several of those out there right now that are kind of fascinating to me. And that is one that's kind of right now kind of on my radar as well. Looking at cases like Adelson, like the case out of Kentucky Veronica, where are my notes? The mom that was going out to get her kids with the visitation supervisor, and grandma and her cronies murdered them. And also the Piketon massacre, and the fact that that was all sort of set up because the grandmother didn't want the mother of the child to have custody of the child. So that's another one I'm sort of mulling over, because it seems like there are more than one case where that's a trend, this whole toxic grandparenthood idea. So that's kind of on my radar too. So let me know what you think. Let me know what you think my next book should be. And with that, I'm going to say thank you so much, Jennifer. I'm going to look forward to reading all your comments. And I hope we're going to talk again soon. I will see you next week, barring any sort of unforeseen pipe breaks, or, they always, the old folks used to say, God willing and the creek don't rise. Well, I had a creek out in front of my house. So God willing and the creek don't rise. We'll see you Wednesday for more true crime. And I'm going to say good night.